As we go back to our top story today, Deputy Minister of Higher Education, he was in court earlier today, as you would have seen in our stories. He's made his first appearance today, and that case has been postponed to the 13th of September. And he managed to be released on bail of 5,000 rand. But whole furore came up where people on social media in particular were saying that it appeared as if the Deputy Minister was receiving preferential treatment. Well, for more on that discussion, I'm now joined in our Seapoint Cape Town studios by Advocate William Booth. Thank you very much for joining us, Advocate Booth. Perhaps we can just start at what is normal procedure if somebody has been accused of a crime and in fact in this case has actually already confessed. What is the normal flow of events? Does one get arrested straight away and then apply for bail, or are there other avenues to get where we got to today?
Good evening. I think one must first of all start and look at what the type of offence is. As I understand the allegations made by the victim, this is one of assault, possibly not even assault with the intent to do grievous harm. So, if somebody is arrested for a serious crime like murder or rape, that person will be arrested and the police can hold that person for up to 48 hours. He appears in court and can apply for bail. The state can obviously oppose bail depending on a number of factors, whether the person is a potential flight risk and the seriousness of the crime, or some of the aspects that are looked at. In this instance, it seems an arrangement was made for the Deputy Minister to come to court and not actually be formally detained, locked up and kept in custody, and then he appeared and he was released on bail. This isn't the first time something like this has happened, and I don't think one must say that he's getting any special preferential treatment, because other people in certain instances like this have also, with an arrangement made between the accused's lawyers and the accused and the prosecuting authorities and obviously the police, have agreed to go to court, be formally charged, and then not necessarily be detained in custody for any length of time, and then apply and be released on bail. But I think the point that needs to be made, firstly, is that where you have a responsible person like a Deputy Minister, particularly of Education, that, a person in that position should not end up in a situation as has happened here. So I think, that is the one point that must be made. But nobody in South Africa should be treated any differently to anybody else. So it's the charge, the seriousness of the charge, and, not everybody needs to be arrested and formally detained for a period of time. If he's not a flight risk, and if the offence is of such a nature that there's no danger to that person being released, well then the law says he should be released.
All right, there's a number of questions I want to ask you. The first one, I guess, is nature of the crime. So intent to do grievous bodily harm, assault with intent to do grievous bodily harm, I'm told is Schedule 1. So is that a serious one?
Yes, it is serious. I'm not exactly sure whether he's being charged with intent to do grievous bodily harm or merely common assault.
Let's assume it's with intent to do grievous bodily harm, because I thought I heard that during the day. Is that an arrestable offence?
It is, yes, an arrestable offence. It doesn't fall within the more serious offences like murder, rape, armed robbery, which fall within the category of Schedule 5 or Schedule 6 offences. But potentially, yes, it is an arrestable offence, and certainly many people have been arrested for such an offence, detained for up to 48 hours, and taken to court. And then depending on whether or not they're regarded as a flight risk, and whether they're regarded as somebody who is a danger to society, they will be released on bail, potentially also under maybe strict conditions reporting to the police station. So the outcry has been that the Deputy Minister has been dealt with differently. But I think the point I want to make is that there have been people who are charged with, let's say, common assault, who have not necessarily been detained for up to 48 hours. Oh. There have been people who have been arrested with assault with intent, where they have been detained for up to 48 hours and where, in fact, the state has opposed bail. But I don't think the minister is a potential flight risk. Okay. So the fact that he's been released on bail...
Let me ask you this. Does your opinion change knowing that he's facing another charge for a similar offence in Ermelo a month ago or last year? So that there's a case number in existence of another assault.
Well, look, obviously that should impact on whether or not he's going to be arrested and whether or not bail is going to be refused. If you are arrested previously and released on bail and you're arrested a second time, then there's a potential to oppose bail. And then it actually becomes a Schedule 5 offence. So, it is more difficult to get bail. So it doesn't seem that he's been charged on that earlier offence, but the fact that a charge has been laid and is being investigated surely should have played a role in whether or not he's going to be arrested. So, or whether or not the state is going to oppose bail. But at the end of the day, I don't think there were any grounds to oppose bail. Don't forget our Constitution says everybody is entitled to be released on bail and everybody is entitled to be presumed innocent. And that should be across the board. But what the NPA and what the police mustn't do is treat people differently. Everybody should be treated in exactly the same way.
What's the potential sentence that he might face if he's found guilty?
Well, again, depending on the offence he's convicted of. If it's a common assault, the usual, and he has no prior convictions, the usual sentence would be a fairly stiff fine coupled with a suspended sentence. If it's assault with intent, there is a possibility that direct imprisonment could be imposed, but normally for a first offender, depending on the type of assault. Obviously, if a weapon is used, then it becomes more serious. But if it's somebody being slapped or smacked, that would usually fall within the category of common assault. So even on an assault with intent to commit grievous harm, people are sentenced to fines, suspended sentences. Things like doing community service is, I think, a very effective type of sentence, particularly where a person has acted and in an aggressive fashion towards somebody else, and then particularly where the person is in a prominent position.
What happens then with the Ermelo case? Does that get brought into this one, or will it be tried separately? And if a conviction happens in this one, that one then becomes more problematic because he's no longer a first-time offender.
It depends when the offences were committed. So the Ermelo case, if that was committed before and he's convicted, let's say, on the second case first, then obviously the Ermelo case, he's first got to be convicted on that. Well, he's first got to be convicted on either of these cases. So if he's convicted on one and then convicted on another, then it becomes a second offence. And the sentences then would be potentially much, much harsher. But again, it depends on whether or not he's going to be convicted. So we mustn't jump to the conclusion that he's necessarily guilty. I think there was some talk of provocation in this instance. So all of those factors must be looked at. He's entitled to plead not guilty, and he may very well be acquitted. If he's not acquitted, well, then you're dealing with two cases that obviously need to be considered, and a prior conviction makes the next case considered from a far more serious light, and that obviously becomes far more aggravating.
All right. Is it a problem for him that he's already apologized and admitted guilt, that he was party to this? Can he now go and plead something else?
Well, I suppose, but he could, but if he's apologized and he's admitted his guilt publicly or on social media or to whoever, then that is a factor that will count against him. And then if he is convicted, it will be, we asked, well, hang on, why didn't you plead guilty to the offence in the first place? So, an admission made to the public is a factor the court can look at if he pleads not guilty. But if he's made that kind of, let's call it a confession, then surely he should go and do the right thing and plead guilty to the offense. On the other hand, maybe his lawyers put in representations to have the case diverted, where he could do a period of community service in exchange for having the charges withdrawn. So there are a whole lot of possibilities here, and one will only have to wait and see. Firstly, what is the charge? Is it common assault or is assault with intent? And exactly what he's going to plead to this charge, and then whether or not the Ermelo charge is also brought in.
All right. I've run out of time, but can a convicted person be a member of parliament?
I believe not.
Okay.
And as I said earlier,
So
to
he
act
might
in
be out
this
of a job.
irresponsible manner is a sad indictment on a person in a very serious position. So it is a factor that will have to be looked at, and he may have to stand down from particularly his position as Deputy Minister.
All right.
And he should if he's convicted.
Thank you very, very much indeed, Advocate William Booth from our Sea Point studio. And some people would say conviction or not, just being party to that should be sufficient for someone to do the honourable thing and step down. We'll